Ms. Campos, go ahead and give me your opening statement at this time.
Yes, Judge. So we did temporary orders on April 16th, 2026. This is a UWIFSA case. So we are not doing orders on conservatorship or visitation. We are only doing orders on supports. And paternity was established in the temporary order. So everyone is in agreement to make that part of the order final. What's not agreed is the current supports. So in the last hearing, Mr. Green's gross resources were found at $5,590. Everyone agrees that this should continue to be his gross income. There's some issues at his workplace right now, which he'll testify to. But I believe everyone is in agreement that this is the amount that it should be once things pick back up at work. And then there was no private health insurance available at this time. So Ms. Berry was ordered to apply for a government medical assistance program, and Dad was ordered to pay medical support at $101 a month beginning May 1st. No one is requesting that change. The request, where the disagreement comes in is last setting guideline support was assessed at $928 a month. Dad has had an additional child since then. Everyone's agreed to give him credit. Guideline support based off of that would be $868 a month. Dad is not in agreement with that amount. I think he'll be testifying that he would like to pay somewhere closer to $750, but I will get some testimony from him on that. There was also a retroactive support finding in the temporary order. I don't believe anybody is asking to change that. Issue of court costs was reserved as well. We don't have any agreement on that issue. And then regarding the non-disclosure, both parties agreed to a mutual non-disclosure of addresses, but they agreed to disclose their email address and phone numbers.
Okay, and they'll tell me, or you'll tell me you said one child, and how old is that child?
There are two children in this case, and they are twins. Their birth date, well, I'll get some testimony about that, but their birth date is 3/20/2024.
Thank you. Okay, then we'll proceed. The state's going to call each of you as a witness, so they get to decide who goes first. So the other person, I'll ask you to remain quiet unless you think you have a valid legal objection. Otherwise, it's not your turn to talk yet, so try not to interrupt, and you'll be given the same courtesy. I promise I'll get to talk to both of you. So, Ms. Campos, you want to go start?
Yeah, I'll go ahead and call Father Mr. Green as my first witness. Mr. Green, can you please state your name for the record?
Antonio Green.
Okay. Did you hear the agreements that I read onto the record?
Yes.
Does that accurately reflect what you agreed to?
Yes, in the sense of me not agreeing to the 868, right?
Right, but everything else,
yes.
everything else
Okay,
that
yeah.
I announced
Yes.
as the agreement.
Yes, ma'am. Yes, ma'am. Sorry.
And I announced on the record that there was a temporary issue at your work.
Yes.
Do you want to tell the court a little bit about that?
Yeah, I mean, temporary, we could say that, but as of right now, it's kind of up in the air. Last time I came on court and I spoke to Judge, I just kind of discussed that TxDOT, we've been having issues with our concrete and it's been having a contamination. So TxDOT was moving forward to disqualify all of our designs that we use to produce concrete. Well, this week is the first week that we've been able to produce concrete. In the last 3.5 weeks, it was 23 days almost that people didn't work and we didn't have work, truth be told. And then so this week is our first week back to try to prove that we can produce good concrete, and TxDOT will be at our job next week. The future of the company from the meeting that we did have this morning isn't looking so well. This was words from my director, ultimately saying something around the lines like, I don't know what's going to happen in the next 3 months. But I do know we're pouring concrete today. That's all he said. And so ultimately we've already lost our plant manager. He's quit. Our safety director has quit. Our batch plant manager has quit. Crane operators has quit because work has become so scarce that we don't know what is going to happen in the near future with our company. So what my director is doing now is he's just going day by day. And the state does come out weekly to kind of like observe and see what they want to do. But unfortunately this week they didn't show up. So next week they will be out to see if we're going to be able to continue to pour concrete or not. And the end game there is if we pour concrete, we make money. Or if we're not making money, nobody has a job.
Okay. But as you said, as of this week, you'll have resumed operations, and then TxDOT will be examining it next week.
Yes, as of this week, yes, we were able to pour 70% of what we would normally produce.
Okay. And then when everything gets resolved, let's say everything gets approved and y'all are able to work normally, will your income be the same as what it was assessed at last setting?
Yes.
Okay. And
But I do
then
have, I'm sorry, I do
okay,
have
go
one
ahead.
question. Let's say in 3 weeks from now, or even a week from now, something happens and this is the final order. And because ultimately I am living in a space where I don't know if I have a job tomorrow. This is words from my director. We don't know. And so if work doesn't happen anymore and I no longer have a job and I have to go somewhere else or find away money, how am I able to send this child support without y'all, I guess, going to my company? How can I manually do something like that just in case? Because I I don't know the status or the longevity of where I do work, and so I just want to make sure that I could still provide the necessary amount that is agreed on. If that happens, I can still try to make that happen.
Just
Okay.
just real quickly, if you're talking about your company just busting up and not having employees anymore, just going down, is that what there's a
Yeah.
possibility of?
The probability is we were a contracted company through another company called JD Abrams, and JD Abrams has already went bankrupt. And JD Abrams went bankrupt, and
Mhm.
so ultimately for our company to start paying all of our employees, we started selling a lot of our equipment, and I'm talking about big equipment like excavators and other things. And so, and then with TxDOT shutting us down for 3 weeks, well, we didn't produce anything, so our revenue for those 3 weeks was zero. And so
Okay.
we are in a bad spot. But between me, my manager, and my director, we've been trying to put our heads together, and other higher ups, we've been trying to like get things dialed in so we can have a job ultimately. But it's looking
Okay.
kind of
I think I get it. I
scary.
think one part of your question, how do you send child support yourself? Go online, get to their website, Attorney General Child Support for Texas, and
All right, guys, today we are jumping into a courtroom case that instantly turns tense the moment the hearing begins. The court lays out a major child support dispute involving twins, financial obligations, and a father who already has other children to support. At first, this sounds like a routine support hearing, but the atmosphere quickly shifts when it becomes clear that both sides completely disagree on what is fair. The state pushes guideline payments, while the father quietly signals he cannot realistically handle the amount being demanded. You can already feel the judge realizing this case may become far more complicated than expected.
multiple ways. And in fact,
Okay.
at the end of this hearing, the state can probably send you a one-page summary of all the different ways to pay directly if it's
Oh,
not
perfect. Okay.
a paycheck. So that
Yes,
just
ma'am.
be forewarned on that. Now, the other
Okay.
question is, do you have a crystal ball? Do I have a crystal ball? And we know exactly what's going to happen? No, nobody here has one. And I'm not even pretending to. If you're asking for hearing and to go to another ruling, I can do that, whether it's final and then I can't review it again because, hey, once I do a final order, the case is over. I don't have any more jurisdiction after 30 days. So you're kind of stuck with it. Then what happens? You'd have to refile or ask to refile, and they may or may not help you right away, and it takes a while to come back. And so if things change drastically in the next few months, I won't have a way of reviewing it if it was a final order. Now, you do want something today because you could get credit for the other child and it would drop your child support a little bit, even if you don't agree with the amount. So maybe I know I have the ability to do this. If I, in my ultimate decision is I do a temporary order, I can do that. If you all want me to do temporary order and reset it for sometime later this year, which could be toward the end of the year, maybe October, November, and maybe things have settled down a little bit and you'd be able to come with better information. I can do that too. Do a further temporary order day and a final order next time. So I'm throwing that out there because those are things I know that you don't, that I might consider, and the state I obviously would want to know their position as well. But I can't help you if I make a ruling today and something goes south tomorrow or next month, and you don't have an avenue of coming back without refiling or hitting the appeal part or a new trial, but that's harder to
Yeah,
do.
yes, ma'am.
Okay, I'm sorry, Ms. Campos, I took over. I'd like to tell people
No,
things, but thinking about it, I'm
that's
sorry.
okay.
Okay.
And let me just ask Mr. Green, because we had talked about doing final orders today and then potentially modifying. And yes, of course, as Judge said, it can take a little bit, like we talked about, to do to come back for a modification. So are you okay with doing final orders today, or are you requesting further temporary orders today?
Only because I'm not sure, I mean, what the future kind of holds. I mean, I guess I would like to further the temporary order. I do have the birth facts or verification of my daughter being born, but I know the judge just said that she wouldn't be able to do that until the final order. Um, and I guess in the meantime, that can also give us a chance to figure out this work thing, check this out, and see about possibly if we're able to put the twins on an insurance, because that could help us out too in a finance way. So, I mean, I would say maybe for the temporary order, and then we could come back and discuss it further.
Okay, I think you got your answer, Ms. Campos.
I did, Judge. And now I'm wondering if we might just want to do a brief recess, because I'm thinking, do parties want to do a full hearing today, or would they prefer to just reset to another day, especially considering this is on YouTube? And maybe they would just, hearing that
Well,
this cannot be the final order today, do a reset
let,
till next.
well, let me ask you real quick. The twins are already born, clearly, but is there a problem with giving credit today so that there might be some
We
relief with that?
We certainly can, Judge. I was just giving the parties the option, since I know there was some hesitation with the YouTube issue and knowing that we're going to have to come back another day anyway. I was just wanting to give them the option of doing either a reset entirely, or we could do further temporary orders today, and do a full hearing over those issues.
But again, is there any dispute that he's got other children that now can be considered that weren't considered earlier? That's not
No,
an issue.
Judge, there's no dispute over that. So the numbers, we were
Okay.
going to recalculate some of the numbers.
Just to be fair, though, for the parties to know is that if I just reset it, then I don't touch anything today. And so I'm not giving you credit and lowering your child support even to an amount you don't want, but it's lower than the original because now you're getting credit for the other children. Uh, if I do a plain old reset, I would expect it in 2 or 3 months versus me doing further temporary orders. I don't mind setting it in 4 or 5 months, however long we have left in the year. That's not December. December's awful. Too many, not enough dockets, too many cases. So I'd say October and November. So of those two, Mr. Green, did you follow that, or do you have any questions before you answer? Which would you prefer?
Yes, ma'am, I follow.
And you would prefer the further temporary orders or the just plain old reset?
Um, well, what's the difference between a reset and a further temporary order?
Well, a reset says I don't touch anything, and the
Oh, I
previous
see.
order is in effect, so I'm not. And then when we come back, I'm not going to be backdating it. Is the problem? It would start from that point forward. We'll think about it. Let me hear from
Okay. All
Mary.
right.
Well, she needs to talk. I need to let her talk. So before I consider anything else, so Ms. Campos.
Yeah, and I'm just going to deal with this preliminary issue right now.
Sure.
Miss Berry, what are your thoughts? Hearing all of this, and knowing that we're putting this on YouTube right now, but we're going to have to come back another day anyway. But we could do some further temporary orders today. What are your thoughts?
Honestly, I just wanted this to be finalized today. I didn't expect to come back again and miss work again because of this. I feel like work in itself is always up in the air. No one knows if they'll have a job tomorrow. And I feel like that's just.
Buckle up, guys, because this is where the entire case takes a dramatic turn. The father starts explaining that his company is basically hanging by a thread after concrete contamination issues shut operations down for weeks. One by one, employees are quitting, equipment is being sold, and even management cannot promise anyone a future paycheck anymore. What makes this moment powerful is how raw and uncertain his testimony sounds. Instead of making excuses, he openly admits that nobody at the company even knows if they will still have jobs in the coming months. Suddenly, this child support case becomes about survival, instability, and fear of financial collapse.
life. However, if we're doing a temporary order, my only question is he still obligated to pay on these temporary orders? Because I have yet to even receive any payment on anything. So the boys, I'm still not getting that financial support. So if I'm okay with including this new child to get the credit that is due, that is okay. But are we going to keep going back and forth, or what are we doing here? Because honestly, I mean, it's just delaying everything. And at this point, I just want to come to an agreement on a number.
Yes, Ms. Berry, I get all that, but as a judge, I also have to weigh both sides, and it looks like we caught him in the middle of a really sketchy time. Most times, we don't know they're coming, and if you had done a final order earlier, or there weren't more children born, it'd be a totally different case, and then he'd have, I guess he'd have to come in and modify it later. And just so you know, if you all don't ask for it, the state is required, I think, by federal policy to look at cases every 3 years to see if they're entitled to modification. So 3 years is a long time to wait for modification if you know today that tomorrow things could be totally different. Now, I've been around for a long time, and most cases aren't exactly this way where you're right in the middle of it. But I have to look at what we're at right now, not what could be yesterday or what could be tomorrow, unless I do a further temporary order and look at the facts tomorrow. Well, by that I mean 3 or 4 months from now, 5 months possibly. So, given all that, I know it's in your interest to get this over and go away with the higher number, but that also might not be fair if he's really in the middle of a difficult situation with employment that he has no control over. So, given that, you want to try again or not? You want a final order today? Is that your position?
Yes, ma'am.
Okay. The state take a position?
Well, Judge, and I do understand that he's going through some changes, and it's kind of up in the air right now. But as you said, we could have also done a final order last month and then it come back and modified if things change substantially. And they don't have to necessarily wait the 3 years if there's been a material and substantial change in circumstances. Of course, as I've told parties, that process would still take a little bit, but we could certainly come back here sooner than 3 years if there's that material and substantial change. And I think I would prefer final orders today, Judge, but of course we leave it up to you.
We have no choice. That's my job. So I misunderstood. I guess I thought it was one child, but there are two children and there's no dispute. So do you have the numbers as far as step downs or any of that?
I didn't have the step downs
But the
pulled up
868,
just, yeah, Judge, but I have
yeah, the percentage that you're using for the new guideline amount for credit for the twins.
yeah, that would be, so he has 3 children outside of this case, and then there's 2 children in this case. So I believe it would be 19% as the percentage. I didn't have those the net resources pulled up, but I believe it is 19% for.
Okay. If I do a further temporary order today, I didn't get enough information because we started focusing on whether to finalize or not. Can you just elicit just a little bit of information about? I don't really want to know what state Ms. Berry is in. If this is UIFSA, there's no custody or visitation. I assume in play in another state already. So I just want to know how far away she is from Mr. Green's location, roughly, and also is there any visits of any kind going on?
Okay, Judge. And so what I was planning on doing was getting some testimony from Mr. Green first, just about because he was requesting that deviation. If you're not wanting to hear a deviation at this point and we're just doing further then I can limit the testimony to not talk about some of the stuff that he's wanting to talk about. But
Well, I guess with the deviation, it would be a deviation if he was trying to visit and trying to spend money trying to travel far away to visit. And that I could consider in a deviation, but I don't know what other deviations he might have. So yes, ask about all of that, Ms. Campos.
okay. I'll go back to Mr. Green. Mr. Green, when was the last time you visited with the 2 children in this case?
Um, they were in the hospital in New Mexico.
Okay, so was that when they were born?
Yes.
Okay, have you seen them at all since then?
No, ma'am.
Okay, and are there any orders in place regarding visitation?
No, ma'am.
Okay. And And just to make it clear on the record, how many other children do you have?
I have three,
Three other children. How many of those children live with you?
all of them. One is of my newborn. She lives with me. She'll be here full time. And the other two, I have 50-50 custody, and they live with me too.
Okay, understood. Do you pay child support for the other
I,
two children?
I do not.
Okay. And so guideline is suggested here based off of at least the income you have currently at $868 a month. Why do you feel that $868 a month is not an appropriate amount of child support?
Oh, well, I was just going off of like what the judge had told me last time, like, hey, calculate all your bills, look at your bills, and so me and my wife, we sat down, quite some time, we looked at our bills, trying to put everything together, and comfortably, I could definitely send 750. I mean, it's about $100 less than that, but even 750 is still a lot, 868 is still a lot. So that's why I figured 750 could be okay, and that we can still make ends meet over here, and she's still receiving $750 a month. That's kind of like where I was, honestly.
Okay. Is there anything else you think that the court should consider on why $868 that the guideline child support amount is not appropriate? Is there anything else that you'd like the court to know about?
I mean, I understand that these boys are mine, and that she does have custody of them, and that she is going to need money. And then I do understand that our newborn, costs money too, and then having kids 50% of the time, they cost a lot of money too. So I get money is the biggest issue here. It's just, however, I just, after looking at our budget and trying to figure out and crunch numbers, it took some time that we kind of came up with 750. That could be ideal.
Okay. Does your wife work?
My wife does work.
Okay. Do y'all the bills that you're referencing, do y'all share those bills?
Yeah, so my wife has her own set of bills that she pays half, that she pays on. I have my own set of bills that I pay on, and then we have tons of bills that we both pay on. In the form of like we do have car payments. We split those. We got mortgage. Insurances. If you want to talk about miscellaneous things like groceries for the house, and just amongst other things that we do split a lot of the bigger bills, and they are expensive. So sorry.
All right, this next moment is where the courtroom tension becomes very real. The father nervously asks the judge what happens if his company completely falls apart after the order is finalized. He is not asking to avoid responsibility. He is genuinely trying to figure out how he would continue making payments if his employer disappears overnight. The judge immediately recognizes the seriousness of the situation and explains that once a final order is entered, reversing it later becomes difficult and time-consuming. That answer changes the entire energy in the courtroom because now everyone realizes they're making decisions while standing in the middle of financial uncertainty.
I understand. Is there anything else you think the court should consider before I move on to Ms. Berry?
Um, Not that I can think of now.
Okay. Then I will pass the witness.
Remind me what the insurance was the government program? I think you said that, correct? Ms. Campos?
Yes, Judge. At this time, it is government medical program.
Is there any way you would provide private insurance that would cover an out-of-state children that wouldn't be astronomical, Mr. Green? Did you hear that?
I'm sorry, what was that, ma'am?
Are you sure there's any private insurance available to you, especially under the circumstances of your employment, that's available to you that would cover out-of-state children that would not be astronomical, the cost?
No, my wife has insurance. I'm on my wife's insurance, and so is the kids. And ultimately, uh, we're gonna see if we could try to get together and figure out if maybe we are able to put the kids on the insurance. And if they do cover out of state, then ultimately the kids can be covered through my wife's insurance if that's acceptable. But and I'm sorry, and maybe I'm already too late. But the one thing I would like to consider is um, the length of our relationship should be considered. That, uh, and I'm probably going a little further, but like Jenica and I only knew each other for a few months before these babies came. Ultimately, and She did move 800 miles away, and so it's not like I was able to have them 50-50, or I am in a position where I can get up and drive 12, 13 miles, I mean 12, 13 hours away to just get up and see these boys, you know, at the same disposal. I'm able to see my kids, which my other kids do live here in the same town as me, but you know, with her just moving, you know, 50-50 obviously would never have been an option because I just can't get up and leave 800 miles away.
Okay. Any further questioning of Mr. Green, Ms. Campos?
No, Judge, I'll pass the witness.
Then let's have Ms. Berry respond to any of this.
Okay, Miss Berry, can you please state your name for the record?
Yes, ma'am. Jerica Berry.
Okay. And how old are the two children in this case?
They are two.
Okay. We've gone over we've gone over dad's income, but we haven't gone over your income just yet. Are you currently working?
Yes, I am.
How much do you, or what kind of work do you do?
So I'm a registered behavior technician. I work with autistic kids. And so basically with kids with autism.
Okay. Is that a W-2 kind of job or a contractor kind of job?
A W-2.
Okay. And about how much do you make per hour on that job, at that job?
I make $20 an hour on average. So my job, I don't really, there's no guarantee for hours since it's subjective to the kids actually showing up to their sessions. So if my clients cancel their sessions, their parents cancel their sessions, I lose out on those hours. So average per week, I would say I work about 30 hours per week. And that's just not including if my twins get sick, I end up losing hours as well. So obviously, because I'm their sole provider here and I don't have my only family member is my sister. She's very busy, so it's just me. So basically, if they get sick, I miss out on those hours.
Okay. And Dad testified a little bit about to his expenses. What kind of expenses do you have?
So my major expenses, like my rent, I do have my own apartment. That in itself is expensive. And then of course everything else like light, water, cable, internet. I have insurance I have to pay on my car, my vehicle, food, mm, diapers, clothes. I mean, what else? Other expenses, just normal expenses. Um, so yeah, that's I mean,
Is there
it's
anyone
just me.
else?
It's just me. No, just me.
And that was my question. Is there anyone else that you live with or helps support you?
No, it's just me. I'm gonna say I do receive child support for my other two children, or my other three children actually. And that helps me with their expenses. So, I mean, that helps me. It doesn't, I still, I pay a lot of rent on my own. It's $2,000 almost. So 2,200 to be exact. So it's a lot for me and for the amount of work I miss out on with the twins being premature. They get sick very often. So most times, like there was a month in April, I missed 3 weeks of work because one of my twins was in the hospital for 2 weeks. So, and then the next twin got sick, obviously. So it was just a rough month for me. And I missed on a lot of work those times. And since it's just me, I don't have other support other than what I receive from my other kid's father. So,
Okay. Understood. Is there anything else you think the court should consider?
mostly that is it. It's just that being also how he stated, we didn't know each other that long. We dated very frequent, like very shortly lived, right? But again, these kids were planned. We discussed this thoroughly before I took out my birth control and we got pregnant. So it wasn't a surprise. These kids, granted, twins weren't planned, but I was blessed with two beautiful babies. So, you know, me moving here was a move when we weren't even together. We were in a bad spot. So we were already separated. We weren't together. So moving here with the twins was my decision as a mother to do what's best for my children and my financial situation at the time. My sister offered her home to me and my kids, and that's why we lived with her for some time. But then I got on my own feet. So that's where I'm at on that. And that it wasn't a situation where he never could reach out or anything. We had ended in bad terms the last time we spoke, but that was 2 years ago.
All right, guys, this is where emotions finally spill into the open. The mother explains that she already missed work for this hearing and still has not received any financial support for the twins. From her perspective, life is uncertain for everyone, and she feels the case is simply being dragged out while she continues carrying the burden alone. But the judge pushes back carefully, explaining that the court also has to consider whether the father is truly standing in the middle of a financial collapse he cannot control. This exchange creates one of the strongest moments in the hearing because both sides suddenly sound understandable at the exact same time.
2 years have passed, and I have no bad blood against him or whatever. I just, it's about the boys and the twins and what's, for them. It's nothing else.
Okay. Yeah, he testified that the last time he saw them was, I think, at the hospital at their birth.
Correct.
Would you agree with that testimony? Okay.
Yes, that was the last time he actually physically saw them.
Okay. I'll pass the witness, Judge.
Okay, technically y'all are here representing yourself, so y'all are your own lawyers. The last thing I do with y'all with testimony is you have the right to cross-examine each other. That means you can ask a question, but then you have to wait for the answer. It's not a time to point fingers or tell each other things. It's just questions. So since Ms. Berry's testifying, Mr. Green, do you have any questions for her solely on the issue, the contested issue of child support at this time?
No, ma'am, I do not.
And Ms. Berry, do you have any questions for Mr. Green?
I don't know, ma'am.
Thank you. Okay. Okay, I don't think I need anything else at this point. Ms. Campos, are you done with testimony and or witnesses and or evidence?
I'm done with testimony, Judge. I'll just do a brief closing, which is that we are asking, I do think guideline support is appropriate in this case. Both parties testified about expenses that they had. And it doesn't sound like Mr. Green has visited with the children. So Miss Berry it sounds like she has taken on that or had to take it all on her own. And I think guideline support, hearing all of the testimony is appropriate. And we are already reducing it from last order since we're giving Mr. Green credit for the child that was just born. So I would just like to reiterate that we are asking for the $868 a month to begin 6/1/2026, and to keep that medical support obligation that was already ordered on the case, since there isn't any evidence of private health insurance being available at this point. And we are going to go ahead and ask for final orders, Judge, but
Ms.
I get
Campos,
that
I think she froze.
oh no.
Who froze?
I think
Oh,
her
me
audio
froze.
is being, Judge, can you hear us just fine?
I can actually hear you, but I see where my screen is. Can you hear me?
Yes,
Obviously,
I can hear
can
you,
you hear me?
Judge. Maybe try turning off your camera and then turning it back on. That might unfreeze you.
I've got a message that says Zoom meeting is not responding. Wait for the program to respond, but you can still hear me?
I can still hear you, Judge.
Go all the way to the left of your screen on the bottom. Turn your video on and off, Judge, on
Okay.
Zoom.
Yeah, I get it. Hold on. Now it's grayed out and it's not letting me access any of the buttons. I'm at a courthouse with really secure internet and a downtown urban area. I cannot believe I'm the one having electronic issues. That usually does not happen. But nothing is happening right now. On my end, I'm clicking for them to.
But
I'm
we
not
can
gonna-
hear you just fine, Judge, and
Okay.
everybody else is. Can you see everyone else?
I can see everybody and everybody's still moving, and I get that I'm the one that's frozen. I did get, but if you can hear me, I can continue. I don't mind. So, So I did hear your last request, Ms. Campos, that you are asking for final orders.
Yes, Judge, and then
Okay.
parties can come back and modify if things change, and hopefully his work becomes stabilized, and we won't have to come back and modify.
Okay. Ms. Berry, let me let you go next. You have the right to make a brief open closing statement. And do you agree with everything Ms. Campos said, and or do you have anything different to add? And really just on the contested issues, everything that's agreed to, I don't need you to repeat.
Yes, Judge, I agree to everything. And just that if 868 is not something that he's willing to agree with and he came up with 750, I can meet in the middle at $800 and that would be okay with me too, just to finalize this order. And that's basically it.
Okay, that's generous. Thank you. And then, Mr. Green, your closing argument, sir. And and I assume you said final order, Ms. Berry, correct?
Yes, ma'am.
Okay, Mr. Green, you're next. What do you want me to do?
Yes, ma'am. I was saying further temporary order. Um, 800 will have to be something I'll have to, sit down and discuss with my wife. But I am still sitting at 750. Ultimately, I don't think finalizing the order today would be ideal. I do think a further order would be okay.
Uh, Let me ask you this. How long have we, I didn't hear it, I don't think, and it will matter to me. How long have you been with the company so far?
Me, I've been there 2.5 years.
Okay. And it's not this company that you think is failing, it's the bigger one that was the problem, that went bankrupt.
Oh no, that company already went bankrupt.
Correct. But your company,
Is now so because they went bankrupt and the money issues, and then also the concrete. Now our company is not doing so good.
okay. Okay, I
Yes,
think,
ma'am.
thank you, sir. Then this is what I'm gonna do. I was close to doing final orders, but I just don't think it's fair because I do know and I have seen, and Ms. Campos, there's no animosity or anything hostile toward the state. You have a lot of cases and too many people asking for help and not enough of you. And so I do see cases that need help 6 months and it happens to be 2 years or something like that. So it's nothing personal, but I do see people having trouble when things change to get back in the system without having to hire a lawyer, which they can't afford. So I am, for the first thing doing is further temporary orders based on the facts I just heard. Um, Keep everything that you already said and continue it in the further temporary order instead of us operating under two orders. So that includes the maternity establishment, all the findings of income, the no private insurance is available, the mother's government medical assistance, and the medical support of 101 a month. That will continue. Did I miss some? Oh, and court costs are still reserved, and the agreed non-disclosure with the exception for email and phone. Just carry them all over. Did I leave anything else out?
No,
That is
Judge, that's
okay.
it. There was just the issue of
The contested
guideline support, and I just to understand what my understanding of Miss Berry's agreement. So I would like to understand if she's still asking, would be okay with the 800, knowing that we are coming back in the judge is ordering further temporary orders, or would she want guideline support?
No, if we're coming back, then we might as well just keep it at the support that I was just saying, if we're gonna finalize it to meet him in the middle, I would say $800. I feel like that's not far. $50 is something you can budget. That's like one less meal out. That's like, you know, work is work and I understand, but this was happening a month ago and we're still in the same place of he doesn't know if he's gonna have a job or not. That was 1 month ago. And we're back here again. A month ago, you didn't know if you were going to have a job, and then now you still don't know if we're going to have a job, and now we're just still furthering something and delaying something on the if. I don't think that's fair. So, if we're just going to do this temporary order, then I might as well just keep it at what is obligated. What is the state is saying is he's obligated to pay.
You may have misspoke a little bit, Ms. Berry. It's not an obligation. It's called a guideline for that reason. It's a starting point. It can be deviated from up or down y'all can take the position you want, but it's not a mandatory thing on me. I get to hear all the evidence and get to make the decision. So just be aware of that. Okay, and if you don't like me, y'all can appeal me. I have at it. Okay, I've talked about all the previous things that need to be in there and that our agreement. I am aware I haven't ruled on the contested issue, Ms. Campos. I just want to make sure all the other stuff was in there first.
Yes, Judge. I'll put all of that in there.
All that in there. The way I see it is from 1 month to another, yeah, I really don't know how anybody can predict if the company's already in stress that it's going to be good or it's going to be bad. I don't think anybody, and nobody has a crystal ball, man. But what I can do is help at least have better information so I can make a better ruling so that for you don't have to come back shortly thereafter. You can wait your 3 years or even longer if things don't change. So what I'm going to do is I'm going to grant the request of a some deviation. I'm going to do $800 a month, whether you like it or not. It's a little closer to your number, Mr. Green. It's not that far. However, what I'm using is I don't think people, just because the kids are far away, are never going to visit. And so I can allow a little bit of credit for trying to visit. And so maybe you can put $50 away for gasoline money for one trip once a year. Or I don't think what I'm giving you in credit would be enough to do plane tickets for everybody round trip. But there is a way of trying to get to see the kids uh, off and on. And or if y'all don't do electronic visitation, you probably ought to start. Everybody uses social media. You can do FaceTime or something else that y'all have access to. But there's no reason you can't start seeing the kids and they can see you on a camera. That's rampant these days with all our electronics. So if you're not doing it, you should be doing it now. I'm not putting it in the order because I don't have the authority to deal with visitation. And since I can't hear it, since the children and mother are not in Texas and this is not their home state. But I like to help people, so tell you, y'all can uh, get something done without a court order on your own. And it looks to me like your children are important to you. If you see your children have 50% of time with your children and don't live with you 100%, Mr. Green. So I would think you would want to try to do anything to get in their heads so they know what you look like. You can see them growing up a little bit. So I would ask you or tell you, you can ask for trying to get electronic visits on y'all's own without a court order. So 800 a month. Did you have a start date in mind, Miss Campos?
6/1/2026, Judge.
6/1/2026, and then I'll look at income based on what I have and keep your pay stubs. The state, you wouldn't. Well, yeah, he's a Texas resident, so you would have his reported wages. However, they may not be as current as the prior quarter, correct? Depending on where we are, Ms. Campos.
Correct, Judge.
It might, yeah. So if you want me to look at your pay stubs all the way to the date of court, you need to keep them and bring them to court with you, or try to put them in an email to the AG before you come to court next time, so that they can look at them for me and then present them for you on the computer. So do that, Mr. Green, because we do not have, excuse me, not we, the state does not have access to up to date. It takes a quarter for for them to find out. So it takes a minute, and they may not have all the up to date information that you can bring to us. So you heard me. I don't care if you wanted me to consider it. You have to bring it, Mr. Green.
Yes, ma'am.
Okay. So 800 months starting June 1st. The last thing I need to do is, and we don't need to do a step down. Nobody's graduating from high school anytime soon, or emancipating. Correct, Ms. Campos? We can wait on that. Or do
Correct, Judge. Yeah, we'll just leave it at 800 for the step down for now.
So again, I am thinking to give it enough time so it won't be every month that you have to come, and you can afford another few hours way down the road, Miss Barry. Let's see, I was saying looking at maybe October, November. This is a Caldwell case. I usually have Caldwell dockets
October
twice a month.
13th is the first October Caldwell date.
Okay, and the other one's an in-person date. I'm not going to make Miss Barry come in person, and I hate the hybrids, part real and part computer. So let's not do that. October 13th or November 10th. Any preference, Miss Berry? They're both Tuesdays.
November is fine, Judge.
That would give it more time for your company to figure this out. Are you okay with that, Mr. Big Green?
Yes, ma'am. November 10th.
November 10th it is. It's going to still be by Zoom. You'll have the same Zoom ID and it would be an 8:30 case as well. So log in and come back in the way you have today. Although it will be in writing, the state's going to draft the proposed order, have you all look at it before they send it to me. You all have about a week to look at it, sign it off on it, but consider it priority homework. So if you can get to do it right away, including over the weekend, send it no later than Monday, because by next Friday, if you haven't signed it, the state will send it to me without your signature, but I will review it for accuracy. And since I'm approving your agreements and ruling on the contested issue, I'm also rendering the order. So it really is my order to sign, whether you all sign it or not. But they are going to give you the opportunity to check for, errors or whatever. In case you see something you don't understand, you can call them. You cannot ever call me. Okay, so November 10th, 2026 at 8:30 by Zoom with the same Zoom ID. Oops, what happened? My battery's low. Let me finish. You have any questions or concerns, Mr. Green, before I let you go?
No, ma'am.
Any questions or concerns, Ms. Berry, before I let you go?
No, I'm fine. Yes, Judge.
Y'all are on legal notice whether or not you sign the order, so I expect you on November 10th. Don't be late, and also don't, if you don't show up, it's a civil matter. The consequence could default you, which means you're not here to tell your side. You're going to lose your case. So it's very important that you're here with your income information. And Ms. Berry, if you want to have input, you show up. If you don't, it goes on without you. Got it?
Yes, ma'am.
Okay. Then thank you. You're excused, and I'll stop my devices once you're out of the courtroom. Click the leave meeting button.
Oh, thank you.
Thank you.
All right, now the courtroom shifts into the final financial debate, and the pressure is fully on the father. The court recalculates support percentages after confirming he has additional children living with him. But the father still argues that the guideline amount is simply too high for his situation. He explains that after sitting down with his wife and reviewing every bill, $750 is realistically the most they can manage without falling apart financially themselves. What makes this segment impactful is that he openly acknowledges responsibility for the twins while also trying to balance obligations toward the children already living in his home.